Good morning. My name is Liza Dawson. I work at the Walter Reed Army Institute of Research. And today I'm going to talk about discussion of how to handle data collected under conditions of noncompliance with human subjects research oversight standards. The opinions I express are my own and don't reflect those of my employer, the U.S. Army, or the Department of Defense. So to give you a little background, this issue has not been really discussed very extensively in the research ethics literature, with the exception of some discourse about data collected under conditions of really egregious human rights and ethical violations, such as Nazi experiments conducted during World War II. In those cases, which involve, again, horrific, horrific violations of human rights and moral standards, don't give us very much guidance about how to handle everyday cases in which there may be noncompliance with human subjects oversight, and we have data that are collected, and we need to have decisions made ethically and appropriately about whether those data should be used. Often these concerns tend to fall to IRBs. IRBs often make decisions about this type of issue, but there's really very little policy guidance or regulatory guidance on point. And it's not clear if we have a really good framework for IRBs to use to handle these kinds of decisions. So one paper that came out that's very useful was written by Mark Barnes, Judith Carithers, and Jeremy Sugarman, three experts in research ethics oversight, who actually took on this issue head on. And they really addressed the issue first by looking at institutional policies among the top 20 institutions that receive NIH funding. They found that among those policies, the majority of them do not speak directly to the issue of use or restriction of use of data. 13 out of the 20 of general provisions allowing the IRB or the institutional official to take corrective measures in terms of noncompliance, but don't address restrictions on data use. 3 institutions had a policy that gave the IRB specific authority to restrict the use of the data, and 4 gave institutional officials such authority. So in this article, Barnes et al. Outline some reasons that are typically given for restricting data use. One is punishment for noncompliance by researchers. A second is lack of informed consent by subjects. And a third is the idea of reinforcing the IRB's authority to regulate research. Now, thinking about this IRB authority, in fact, IRBs do not have explicit regulatory authority to restrict the use of data, with the exception of their authority to shut down research protocols or to ask for modifications of protocols for human subjects reasons. However, if a study is already closed and data have been collected, the IRB doesn't actually have explicit authority to mandate what should happen, what should or shouldn't happen with that data. But the authority could be inferred from the fact that if IRBs don't have enforcement mechanisms, then there's no way to be sure that researchers have any incentive to comply with the rules. If they can collect data without being in compliance with the human subjects regulations and continue to use the data, then perhaps the IRB's authority really lacks teeth. So this inference about IRB authority is what's mentioned by Barnes et al. As probably an important consideration in giving IRBs a role. Now, the Barnes et al. Do provide some specific recommendations. They believe that data should be restricted in certain cases, such as serious and continuing noncompliance, failure to obtain consent, or damage to scientific integrity of the data. They do mention that that might not be within the IRB's purview and might fall to others, perhaps the research integrity officer at the institution. And they make good arguments about why data should be used in most cases outside of these 3 scenarios. Don't waste the resources that have been expended in research. Honor study participants' contributions and desire to contribute to the study. And basically, the value of research, the social value of research, really should accrue generally to society at large by gaining understanding and knowledge from research. And it's intended primarily for the benefit of individual researchers. So don't waste this valuable resource by not using the data. Now, I agree largely with the framework that they offer, with some exceptions. I believe more nuance and more specificity is needed for some of these cases. For example, serious and continuing noncompliance may not warrant sequestration of the data, and sometimes consent issues can be addressed to allow ethical use of the data, even if there has been a failure of consent. Furthermore, on the side of research integrity, I believe we should not give IRBs the authority to regulate those types of issues. There are other scientific oversight mechanisms. So I'll go through those in a little more detail, but I'm also going to give you some case studies to reflect on, to think about how these things might play out in practice. These case studies are loosely based on real scenarios that we've encountered. So this case study, the first one, is a study of sleep restriction and how it affects cognitive performance. We're a military research organization, and the military is very interested in the effects of sleep, lack of sleep, or restricted sleep on performance for military troops, but it's also actually quite relevant for civilians. In a particular study, there was persistent protocol noncompliance by the principal investigator. There was a failure to adhere to inclusion and exclusion criteria in enrollment for the study, other protocol violations concerning appropriate documentation and adhering to the study schedule, et cetera. However, there was no evidence that participants were harmed or had increased risk due to these violations. A co-investigator on the study was assigned to take over responsibility due to the failures of the PI to adhere to the protocol. In fact, I believe that person lost their job over this incident. But in the end, the data were sequestered by our Human Research Protections Director, and they were not used. So my commentary here is that we don't have evidence that the data were scientifically unsound. Therefore, even though there was serious and continuing noncompliance, I don't believe that this warrants restriction of the use of the data. And there was a significant effort by the study team and the study participants to complete these study procedures, which in some cases rather onerous. People had to stay up for many, many hours at a time and then complete various tests and assays. So in a sense, this effort by the study team and the study participants is now essentially wasted if we don't use the data. So study number 2 is an observational study conducted in the context of clinical care for patients who live with HIV. The study, as it's observational, there's no clinical interventions being delivered here. It's simply a questionnaire and blood draws. The blood is used for various immunologic assays for scientific research questions, does not involve the management of their clinical care. Pregnant women were included in the study, and because of pregnancy, the blood draw volumes that were used to gather, the blood for these assays was reduced to make it less burdensome for pregnant women. But on several occasions in the study, a standard blood draw, not the reduced volume, was used because the study staff had failed to recognize that there was a note in the patient's chart that the individual was pregnant. The IRB reviewed these cases, and because there were quite a number of them, I think maybe half a dozen of these cases, where there was an error by the study staff, they determined it was serious and continuing noncompliance. But there was no discussion of withdrawing data from the study. So this is another example in which I think serious and continuing noncompliance does not warrant restriction of the data. And in fact, we don't want, in this particular case, we don't want to fail to collect data on pregnant women. This is one of the areas in which we feel there's usually an under collection of data, and we need to continue to allow pregnant women to participate in research when they can do so safely. So a third case study involves acute HIV infection and early treatment with antiretrovirals during the period of acute infection, followed by a treatment interruption and use of a novel anti-HIV agent, which is designed to suppress the replication of the virus. Now, this study involves a very hard to reach population, hard to find and enroll population of individuals who have been identified as acquiring HIV infection within a few days from the time of acquisition, and they're offered enrollment in research during this acute infection period. It's very difficult to find people because when you screen people for HIV, you usually find people who are either uninfected or have been infected for some time and are simply unaware and finding out via an HIV test. But these acutely infected individuals, you actually have to screen hundreds and hundreds of people to get a handful of people who are in that acute infection window. In this study staff mistakenly drew one extra tube of blood during a study visit for a participant, which is a protocol deviation. It was done in error. And the IRB in charge stipulated that the data from that participant may not be used by the researchers due to the violation. Now, in this case, there was no evidence of harm, and the deviation was in fact quite minor. But the issue is that even one participant in this study represents like a significant amount labor and effort and time on the part of the study team, and the commitment of this individual to undergo study interventions and treatment interruptions, which is quite a significant commitment on the part of the individual as well. So not using the data, again, is really doesn't allow us to take advantage of the social value of those commitments and that effort, and essentially that effort is wasted. So this, I think, is a situation in which I think Barnes and company would agree that the data should be used because there was not a question of serious and continuing noncompliance, but the IRB in this case decided otherwise. Case study number 4. Researchers are conducting focus groups with soldiers to understand attitudes and experiences during current deployment. They have approval to enroll a certain number of study participants for this focus group study, a minimal risk study. They'd like to increase the number of participants. The study is overseen by 2 different IRBs, one at the research site and one at the parent institution. So the PI prepares and submits an amendment to increase the study enrollment. And the local IRB says that an amendment is not needed, but the parent institution will not approve the amendment unless the study site approves, the local site approves first. So meanwhile, study participants were actually enrolled in this increased, numbers of focus group participants. Eventually, the parent institution becomes aware of this deviation and does grant permission to use the data from the focus groups that were over-enrolled. Now, technically, this over-enrollment is conducting research without IRB approval because there wasn't approval to enroll those participants prospectively. So this might fall under the Barnes restriction of that this was done unauthorized enrollment of research participants. However, in this case, there's really the violation is not that significant since this is a minimal risk study and there was no additional risk or harm from this over enrollment. And it was really sort of an unfortunate bureaucratic snafu. So I think these cases illustrate that there's sometimes really a lot of nuance in deciding whether or not to restrict the use of the data. And in most cases, use of the data as a default presumption is the right course of action. So that's in fact our first recommendation. The default presumption should be the data should be used for all the reasons already outlined to honor the research participants' contributions, don't waste these resources, provide the value to the society from the benefits of research, and also if you need to deter or punish researchers, do it via some other mechanism, not by restricting data use. Potentially removing some data from a study can skew or the results of the study or damage the study. In the case of the HIV study with acute infection, a diminution of the data collected actually harms the value of that study with that hard to enroll population. And other stakeholders also have an interest in the use of the data besides the researchers and the institution itself. The other collaborators also, for example, or people who are have agreements to use the data then may be harmed by not being able to use the data as planned. Recommendation 2. There are situations in which it's reasonable to restrict the use of the data. Lack of informed consent is one reason, and this is because consent in itself is an authorization to perform procedures and to use data, and lack of authorization could be a serious ethical concern. However, it needs to be handled on a case-by-case basis. There are times when, even if there's a lack of consent, this may be able to be addressed, and I'll outline some ways that can be addressed. A second condition in which it's reasonable to restrict the data is if there's potential harm to subjects or others from use of the data. Now, for example, I didn't have a case of this type, but for example, if use of the data might cause social harm to a group of individuals due to the type of findings that are that would be implicated, that might be a time when restrictions on data use would be warranted to prevent further harm. Scientific integrity is the third reason. I agree with Barnes et al. That this is a good reason to restrict use of data. However, I don't believe that it should be handled by the IRB. And I will outline a few issues there also. So the first issue about informed consent, as I mentioned, I think this is a special category because the authorization to use, to conduct study procedures is part of our respect for individuals' bodily integrity and autonomy, and it's a very important principle of research ethics that we hold those principles to be fundamental in our research. However, there are times where there's an oversight with regard to consent issues that can be remediated. For example, we might have a clinical care procedure in which specimens and data are gathered And there should be an opportunity to ask people to consent for future use, and maybe that opportunity was overlooked. So there was no authorization for future use. It might be that the IRB might find a waiver of consent to be acceptable if that's a minimal risk to the person and doesn't violate their rights. Another option is there may be an opportunity to go back and ask for a consent after data were erroneously collected in order to respect the autonomy of those individuals to decide about use of the data. So there are opportunities here for these issues to be addressed. And I believe this should be handled on a case-by-case basis. And I think it's appropriate for IRBs to make these determinations because these are issues that IRBs handle routinely, is about how to protect the interests of research subjects and to make sure that their rights are not violated. So that's part of the recommendation on consent. The recommendation regarding scientific integrity, to drill down on this a little bit further, the RIO, the Research Integrity Officer, is responsible for handling allegations of scientific misconduct that fall under the regulations, the fraud, fabrication, and plagiarism. So those, as we know, the RIOs handle those by following up with allegations and investigations if appropriate, and then making recommendations to institutional officials. Those type of issues are not the IRB's purview. They do fall under the RIO's role. So I think that's appropriate to outline in institutional policies. Now, what about other types of scientific integrity? For example, suppose inappropriate inclusion-exclusion criteria were used, which invalidate the data for the study's main investigative purposes. Those are not FFP issues. Those are not RIO issues. Those would be scientific issues. So in certain cases, there are scientific oversight committees or groups that should oversee those decisions, such as a study steering committee, a DSMB, maybe departmental oversight. Those types of issues need to be handled by scientific experts, and they're not regulatory issues. They're scientific issues. They do deserve proper adjudication. I definitely do not think those are issues that fall under the IRB's purview. I think the institution should take the lead on determining decision-making in those cases. So recommendation 4 is addressing this concept of whether investigators need to be punished or incentivized more strongly to follow the rules by not, by having certain types of sanctions. So I believe, again, restricting the data is not the right way to address researcher noncompliance. Institutions can take other actions. For example, they could mandate additional training for researchers who are non-compliant, supervision by others, increased monitoring of the studies. They can remove the research from the PI role to assign the role to another individual, or they could remove the PI completely from the study. They might prohibit the researcher from leading any other studies or even terminate employment in cases of very, very serious noncompliance. I recommend that institutions develop policies and procedures for handling these issues such that there's a clear pathway and a clear line of responsibility for making sure the issues are addressed with actions that are proportionate to the type of violations that occur. Now, the IRB can take some actions. They may ask for increased frequency of continuing reviews in order to more closely monitor the study, or additional reports to the IRB on compliance issues to make sure that compliance problems have been addressed and corrected. Now, those are in the context of IRB's own oversight over studies. The IRB, I believe, does not have the authority to take those other institutional actions. And again, I don't believe the IRB should use restriction on data use as a mechanism to deal with the researcher's own behavior. So in summary, we have recommendations that institutions develop more comprehensive policies about use of data when there was noncompliance with human subjects protection standards. IRB decisions should be primary when the use of the data could cause an increased risk of harm to human subjects, and also with regard to informed consent violations. But institutional decision-making should be primary in cases where the real issue is researchers' behavior that needs to be sanctioned or researchers need to be removed, and also in cases of scientific integrity. And the default presumption, I think I would agree with Barnes et al. That in most cases, data should be allowed to be used. The 3 cases, risk of harm, informed consent, scientific integrity, as outlined, are good reasons why data restrictions might need to be put in place. Thank you very much for your attention. I appreciate the opportunity to give this presentation.